versus AHA Mechanical Contractors, LLC.
May I take the photo, Your Honor? Greetings, Your Honors. My name is Matt Galata from the Memphis Bar, and I represent the plaintiff appellant, Mike Snodgrass. I'd like to reserve 2 minutes for rebuttal.
All right, 2 minutes.
Thank you.
May proceed.
Your Honors, this is a Fair Labor Standards Act case, and it involves unpaid overtime. And the FLSA places the burden for proper timekeeping squarely on the employer. Now, Mr. Snodgrass had actually agreed in this case to be paid a flat 40 hours over the course of his little over a year employment with AHA, but the record shows that he frequently worked over that 40 hours. This case is unusual to the extent that it features the use of a GPS system, which was called Street Eagle, which was not really designed to keep working time records, but was used in this case, and it's undisputed that the defendant frequently would review these records to keep track of Mr. Snodgrass's hours. So when dealing with imperfect records, the particular case that applies here is the burden shifting paradigm and Anderson versus Mount Clemens Pottery, which is a Supreme Court case. And essentially under that test, the employee has the burden to put forth evidence that they worked unpaid overtime, and then the burden shifts to the employer, and the employer would have to negate the reasonableness of the inference. That's the quote from Mount Clemens. So our first issue in this case is that although Mr. Snodgrass did meet his initial burden, and that was something the trial court found, the trial court also found that AHA...
Let me ask you, how did the employee go about meeting that burden?
So the employee just testified. First, they offered proof of the GPS records, and those
But that
were offered.
shows the position of the vehicle. It doesn't really show whether the employee was involved in work activities, does it?
Well, I would say that it generally did, and I think that the record bears that out, that it would show, it was attached to the company car, and it would show when he switched on the engine and when he pulled into his home and then switched off the engine. So on a typical day, I think it did show that. There were times where it would perhaps not show that, for example, if the vehicle was undergoing maintenance. But the trial court found that the GPS records were adequate, along with the testimony of Mr. Snodgrass, and he gave pretty detailed information about what he would do on a typical day. And his duties were quite varied in that accord. So the trial court did find that the records in this case were adequate. So
Did the appellee raise as an issue the fact that the plaintiff didn't reach its initial burden? Was there any issues raised by the appellee that would contest that?
well, I think that the appellee essentially is saying that I think what they're saying is not so much that he didn't meet the initial burden. They're certainly criticizing that he supposedly failed to clock in, and that there was supposedly a system where he clocked in. But I think the main argument, my understanding of the main argument here is that not so much that the initial proof wasn't reached, but that they negated the argument under Mount Clemens. They negated any proof that there was that initial showing by proving that Mr. Snodgrass was not working. And forgive me, I may have not answered your question, but I think that their argument really focuses more on that they negated that initial burden.
What was the proof that negated it?
Well, and we'd argue that there was no proof, Your Honor, that was adequate to negate it. Mr. Snodgrass, I think the GPS records are adequate to show that he was working, along with his testimony. But I think that the GPS records are not adequate to show that he wasn't working. And I know that sounds like we're trying to have it both ways, but the fact of the matter is it's not supposed to be a very onerous burden for the plaintiff to show that he worked. And
I
on
guess my question is if the court essentially made a finding that your client met their initial burden, and the appellee has not raised that as an issue. So if that's the case, then how can they argue that your client didn't meet their initial burden if it wasn't raised as an issue?
Well, I think that he did meet his, my understanding is that he did meet his initial burden, and I don't know that they really dispute that, but I think on the flip side, they're saying under Mount Clemens that it was rebutted, that there was evidence put forth to show that he wasn't working. So it's that burden shifting paradigm in Mount Clemens where the burden doesn't shift until we meet our initial proof, and then they have to, the language that's used in Mount Clemens is negate the reasonableness of the inference. So, and they argue that happened, and the trial court found that it happened, that basically, that there was evidence that Mr. Snodgrass just simply wasn't working. And I may be misunderstanding the question, Your Honor, but is that, okay.
It's a very confusing situation. I've been trying to grapple with it, because if the court found that your client met its initial burden, then it must have found he was working.
Well,
How would he have met his initial burden if he wasn't working?
Well, Mount Clemens, the case is designed around essentially a system for recording time, and I think this was back in the 30s where it was at a pottery company, and there was this imperfect system to record time that didn't actually show the exact time that the employees were working. And Mount Clemens is applicable in this case because these GPS records are not perfect. And so in Mount Clemens, they created that burden shifting paradigm. And I'm right with you, Your Honor, that I think it's confusing. Essentially, I think we have to put on a prima facie showing that he worked, and then if we rested at that point, and they were not able to offer anything further, then we would essentially win the case. But Mount Clemens would essentially allow them to try to rebut that reasonable inference.
Counsel, under the CFRs in this case, can a trial judge take hours from week one? Let's say the client didn't work 40 hours in week one, worked 20 hours in week one, and then in week two, worked 60 hours. Can a trial judge balance those out, or do you have a violation with regard to overtime pay in week two, and we just sort of, and the trial judge can't take in those 20 fewer hours from week one to balance it out?
The Fair Labor Standards Act just simply doesn't allow that, and I think there's two reasons. One is that it's public policy, it's a humanitarian thing. It is designed to make sure that the employee is compensated for that time and a half for time they work over 40, which is really kind of putting them out. And it would also allow the employer to just sort of negate that. They would never have to pay overtime. They could just move things around, and then the FLSA, the overtime portion, would have no meaning at that point. So, and
in this case, you also have the lunch hour taken out sort of each day that's being taken out by the trial court judge. Was there any reporting mechanism the employer had that would allow the employee to say, I didn't take lunch today, I worked during my lunch day? Was there any reporting mechanism that was available for that?
There wasn't, not, Your Honor, and there was, of course, the White case, which there was a reporting mechanism where the employee essentially would have had to report if they didn't get an uninterrupted lunch break, so that would be credited to their pay. In this case, there was no system for that at all, and actually both sides concede that he didn't get an uninterrupted lunch break, and that at most he would get to eat a sandwich from one work site to the other.
Was there any reporting mechanism for him to report overtime, that he had worked overtime?
There wasn't a specific system. There was a dispute of fact in this case. And this is something that's actually referenced in the Court of Appeals order. And it's AHA's position that Mr. Snodgrass actually refused to clock in. And he says, hey, this was an agreement to work 40 hours, and I was paid for 40 hours. So there's essentially, there was essentially an illegal agreement here to begin with. So it's not as clear as it could be, but I would say that's a dispute of fact, that it just, why would he have to clock in if they're not keeping track of his hours, because they're paying him 40 no matter what? So.
Because if you don't keep track of it, then you can have a claim like this, that he worked overtime. That's why you keep track of it, isn't it?
Oh, I agree, Your Honor. And the AHA claims that they did, I don't know if we can really presume that they were aware of their duties under the FLSA. They made an agreement with him, which was, given that they were actually monitoring these GPS records, they would have known that he was working more than 40 hours. They weren't paying him for any of that time.
I'm still confused about how tracking GPS tells you whether or not an employee is engaged in compensable work activities. Because you could drive the vehicle to an abandoned lot, leave it running, GPS is still tracking it, but there may not be any work activity. Are you saying just because they're tracking the vehicle, that any time spent parked on an abandoned lot, not engaging in any marketing of the business, the employee is entitled to pay for that activity?
I think so, Your Honor. The fact of the matter is a time clock wouldn't show that information either. It would still take the testimony of the plaintiff that he was working. And I think that would be a good argument. Of course, AHA says that they say that that Mr. Snodgrass was, as you said, working in, that he was in abandoned lots and they didn't know what he was doing. That might be a good argument if he had a different role, if his job was essentially that he was a technician and he was to install HVAC systems, and that was all he had to do, and he would always be in a certain place. But Mr. Snodgrass also had office-type duties. He had to answer a cell phone and be available to take calls. He did paperwork. So he was called a jack of all trades. That was really undisputed proof on the case. So, and Mr. Snodgrass even said, yes, sometimes I would go out and I would sit in my car. I would look at the planned route for the day. I would read the newspaper, because he was told to look at the Memphis Daily News or the Daily News in order to find potential leads for sales, for future sales. So I think
Is all of that testimony in the record?
yes, Your Honor.
So he testified that during this time, during these periods of time when he was sitting in the truck and whatever, and during these GPS periods, that he was in fact working?
Yes, Your Honor, absolutely, he did.
Was there any evidence to refute that?
Well, I would argue it's just purely speculative. AHA said that one time, Ms. Berlin, I believe, said at trial that there was a particular instance where she thought he was sleeping, and he testified that, well, I was just looking down and looking at papers. And of course, the fact of the matter is he gets a 20-minute break during the day. So even if she didn't observe him sleeping it didn't say how long she observed him supposedly sleeping. So it may be that he had that he was just taking a break, but he denies that. And I'm out of time.
You have your rebuttal.
Okay, thank you, Your Honor.
Mr. Frick?
Good afternoon, Scott Frick of the Memphis Bar. I feel like we're having a bit of a reunion here. It's good to see both of you again. And Judge Usman, congratulations on your appointment. As I said, my name is Scott Frick. I'm representing AHA Mechanical in this case. Other than Judge Usman, I'm the newest person to this case. I did not try the case either in general sessions or down at the trial court, and I was not counsel for AHA Mechanical in the first appeal. I've took over actually late into this appeal when the brief was due, and I appreciate the court granting me an extension of time to be able to file a brief in this case.
Mr. Frick, I want to follow up on Judge Usman's question earlier. about the manner in which the court addressed the time issues in this case, and it appears that what the court did was, and I can't quite figure out how the calculations occurred, frankly, but it appears that what he did was take cumulative time from that the plaintiff says he worked, and then took cumulative time on the other side, and said that these times offset the overtime that the plaintiff, that Mr. Snodgrass was entitled to, and so basically decided it on that basis. I mean, isn't it true that the Fair Labor Standards Act requires that a calculation be made of each pay period?
That is correct, but I think we need to get to a more fundamental underlying question is, why are the records inadequate? Why is there a problem with the records? And the reason why there is a problem with the records is because the plaintiff did not utilize the time clock. And what's so critical about that, and
did the employer enforce the use of the time clock?
They consistently told him, you have to use the time clock, and he simply refused to do it. I mean, that is the undisputed proof in the record.
How long did he work not using the time clock?
A year, I believe over a year. And but this is all of the cases that I've cited, because, first of all, before we even get to this burden shifting issue, there has to be a Fair Labor Standards Act violation has to be proven. And the critical thing here was that if there had been no time clock, this would be a very different case. The problem is, and again, Sixth Circuit case law as well as case law from numerous other circuits is very clear that the employer's primary responsibility is to put up an adequate timekeeping system. And if they've done that, then it's the employee's responsibility to utilize that timekeeping system if they're going to claim somewhere down the road that they did not get compensated for their overtime.
Counsel, on the aspect of that adequacy of the reporting system, there are issues about lunch, there are issues about overtime, obviously the big driving factor here. Was there any reporting mechanism here for the employee to say, I didn't take my lunch, I had to work through my lunch today because I had a call where I had to go somewhere? Did the employer provide any mechanism for reporting that? Did the employer provide any mechanism for reporting overtime?
Yes, it's the time clock. He was supposed to use it. It is undisputed in the record that he was supposed to use the time clock. He refused to do it.
About how that applies to overtime and to lunch? I mean, is there a notation on there? You clock out at lunch, you clock back in?
This is very similar to what I would argue was what transpired in the White versus Baptist Memorial Hospital case. They had kind of an automatic timekeeping system, and if your lunch break got interrupted, there was a log that the employee could go to and say, well, 15 minutes into my break, I got called back onto this shift because we had a patient came in or whatever, and then they would go back and account for that and add that time back into the system. The problem, and the federal case law is so abundantly clear, you can't sabotage, an employee cannot sabotage the employer's efforts to keep accurate timekeeping, to keep accurate time records. That is precisely what Mr. Snodgrass did.
Mr. Frick, it seems a bit disingenuous for the employee to argue that the plaintiff didn't use the time system when it's the employer's time system, and he was employed for a year and a half, and all during that time, your client kept giving him raises. He started at $750, then I think he was ultimately being paid $17.50 or something, some number like that. He got half a dozen raises during that entire time, and during that entire time, your client knew he wasn't following the rules. He wasn't using the time clock. Instead of firing him, you kept giving him raises. And now you're coming up here and saying, well, he can't pursue this because he didn't follow the rules. Your client didn't enforce any rules.
All I'm telling this court is what federal case law says. And there is no requirement under either the CFR or under any of the any Sixth Circuit authority, in any Sixth Circuit case or any other one of the federal court of appeals circuits that says you are mandatorily required to fire somebody if they refuse to use the system.
I didn't say you had to fire him. I'm just saying that was certainly an option you had. If you're going to come up here and say, well, he didn't follow the rules and that's why we're here, and you continue to give him raises, does that not seem a bit disingenuous?
Not at all, because the problem is he's trying to make a claim for overtime. And if he wants to preserve his claim for overtime, he has to utilize the employer's system for keeping track of the time. That's the only thing he's forfeiting here. Part of the issue, and this is in the proof, was the fact that there was a personal relationship between this individual and the Berlans. And they unfortunately made that mistake that sometimes it's just not the best idea to hire your friends and bring them into the business. They felt bad for him. He'd been unemployed. Now they're getting, they're seeing, I guess it's an example of the old saying about no good deed goes unpunished. But the simple fact remains that he got paid for his 40 hours. And if he wanted to, and this is kind of one of the interesting things that my client always keeps saying to me, it's like, I never have any, if somebody's worked overtime, by golly, they let me know before that payroll period's up. He waits until he's terminated to come up with an overtime claim. He got paid for his 40 hours. If he wanted to maintain a claim for overtime, he should have done two things as required by federal case law. One, he should have been maintaining some other contemporaneous records, because the case law that I have cited says that just generalized testimony that, well, I was doing this or I was doing that doesn't count. The other thing is, if you want to maintain your claim for overtime, go clock in and use the system. As I said earlier, if this case, if we had not had a time clock and had he not been asked to use it, this would be a very different case. He created the problem. And he created the problem because he refused to use the time clock. And they were left with the alternative of, well, let's look at the GPS records, and there was no viable explanation of why he would be sitting off in a lot in someplace where where he's supposed to be calling on customers to be making new sales.
Well, it sounds like what you're saying is that he didn't meet his initial burden, but the court found that he did meet his initial burden, and you didn't raise as an issue in your appeal that he didn't meet his initial burden.
I disagree with that.
Where's the issue?
It starts on page 10.
You didn't raise any issues. You have to raise it as an issue. Did you raise it as an issue?
Am I required to raise as an issue that I don't believe so, no. I mean, my argument is that he did not meet his burden.
An argument without an issue, you have to have an issue, and then you get to argue about it. But I didn't see any issues in your brief. You didn't raise it. You didn't raise an issue that he didn't meet his initial burden. The court found that he met his initial burden.
I would say that that's arguable on that, because
What's arguable?
well,
Did you raise it as an issue that he didn't meet his initial burden?
that it's arguable that the court found that he met his burden.
The court said that in its order.
I disagree with that. I think when you look on page 11 of the order, starting at 32, I do not believe that the court states that he met his burden. I mean, there's one of the critical issues here, that in order for this burden shifting to take place, he has to prove an FLSA violation. The case law is clear, and I quoted in the brief, that if you do not establish that there was a violation of the Fair Labor Standards Act, you don't get to shift the burden.
So that paragraph 33 you say that's really not a finding by the trial court that the employee met his initial burden.
I agree with your statement completely. All it merely states is the parties stipulated to the accuracy of the GPS records, and both parties relied on those records in their case in chief to meet their burden of proof as such that the court finds that the records are adequate.
The court said that you rebutted the reasonable inference. Now, what would be the reasonable inference if the court didn't find that he met his burden? That's the reasonable inference.
But the problem is, you
There's
don't.
nothing to rebut unless he met his, unless there's a reasonable inference.
Okay, and so let's say for purpose of argument that he did meet his burden. The court has found that the inference was rebutted.
Well, I understand, but the point is, the court held that he met his burden, and you didn't appeal that. So you can't say that he didn't have proof, didn't meet his burden of proof, because the court said he did. Then the burden shifts, and that's not. But you didn't appeal the issue of whether or not he met his burden or not. So I don't think you can argue that he didn't put on enough proof to meet his burden, because the court found that he did.
And as a matter of law, he's not entitled to recover anyway, because he is required. Federal case law is abundantly clear that you don't get to sabotage the employer's efforts about maintaining adequate records, and that's precisely what Mr. Snodgrass did. And you can't then meet your burden by then arguing that, or by not having some sort of contemporaneous time records to make up for the fact that you don't have records to show what the overtime was.
So from a review of the record, there was no testimony at trial that he ever complained about working overtime and was not paid.
Correct.
Was there any claim at trial that he worked through his lunch hour and was not paid for that time?
He offered that, I believe, as an explanation as to why the 1 hour should not have been deducted in making the determinations of the time that he worked.
Wait a minute, did you say there was no testimony at trial that he worked overtime? Is that what you said?
That he reported having worked.
You're right, that he reported
that he
it.
worked overtime.
Correct.
Right.
No, he did not, during his entire tenure, I believe I'm correct in stating this, there is no evidence that at any point while he was employed did he ever come and say, I worked overtime last week.
And you're saying that the Fair Labor Standards Act, the law supporting that, requires that he make that demand while he's employed?
No, what he's required to do is to comply with the employer's timekeeping system. That's what he's supposed to do.
That the employer doesn't enforce.
There's no case law that establishes that. Federal case law says that if the employer has established a reasonable method for keeping track of the employee's time, the employee has to comply with it.
Let me ask you one other question. The time records that are part of the court's order, the weeks that he worked, and which the court supposedly considered in this case, go through April. I think there's 3 weeks in April. Beginning April 1, 2013, the week of April 15, and the week of April 22nd. That were part of the court's order in this case, and assuming that the and I believe it's correct that the court did this on a cumulative basis. Do you agree with that? That the court accumulated all of the time on each side and determined that there was an offset in the number of hours that he was entitled to for overtime versus, and found in your favor that he was not working a number of hours, and that just offset the cumulative amount of time that he was claiming for overtime? Is that the way the court did it?
I believe that the way the court did it, and again, I wasn't there, so I may be a little off on this, but My understanding was that the court looked at the idling time when there was no viable explanation as to why he was in an abandoned lot somewhere, and deducted that to then come up with the amount of time that he actually
But he didn't
worked.
do it on a pay period basis.
I believe that they did, because.
You believe that he determined it, each one of these on a pay period basis?
I believe so, because, for instance.
Well, I mean, I realize he set it out on a pay period basis here in the order, but that's not the way that he actually made the determination of the 6 hours and 11 hours and whatever he was talking about, because there's a lot more time here than that. And one other thing, the basis, this Exhibit 5, I think, was mentioned, which has the monthly totals of non-work-related activities, and it goes from June of 2012 to March of 2013. It doesn't even include any of these April hours. It's not even included on this exhibit. And this is apparently the exhibit that I think both sides agreed with, the court relied upon in making its ruling.
Well, I think the court relied upon the totality of the time records that had been put in, or the GPS
totality.
records that had been put in. Well, I'm saying, what I'm arguing is that the trial court didn't rely specifically on Exhibit 5. There was an entire notebook of documentation. Thank you.
Let me ask you one final
Yes, sir.
question. Is an employee entitled to overtime pay if he or she elects to work overtime without the knowledge or consent of the employer?
If you could run that by me one more time.
If an employee elects, without the knowledge or consent of the employer, to work overtime and never advises the employer of that, is that employee later entitled to compensation for that overtime pay? As you understand it under the FLSA.
I believe under the case law that I've cited, that employee would not be entitled to that overtime.
Okay.
Because they've got to utilize because I think that, and I've forgotten, pardon that, I don't remember what the case was, but there was a case that I referenced that involved a police officer that I believe had been on some sort of multi-agency task force or something like that, and that was precisely the issue that he had. He was working overtime, he wasn't reporting it to the city, then he's terminated, and then he comes in after the fact, and the court found that the city did not have an obligation to essentially go mine its records to determine that he had been working overtime.
But before you leave, Mr.
Yes,
Ford, one final question. Are you saying that you're not aware of any cases under the FLSA
I have that problem too.
where employees have left employment and had never advised their employers of that they had worked overtime, where they haven't been required, where employers haven't been required to pay overtime, even after the people?
Oh, I believe that has happened. Yes, I believe that has happened.
Where they never reported any overtime, correct?
I believe that is the case, but there's an issue that they have to have some records, and more than just generalized testimony, they have to have some contemporaneous records or something, and they can't just get up and say, oh, well, I worked 60 hours that week.
And these GPS records, these were your client's records that your client introduced into evidence.
That's correct. That's correct.
Thank you.
Thank you. Good to appear in front of all
Good to
three
see
of you, but
Nice to see you
our
again,
former
Mr.
Shelby County.
Nice to see you again. You have your rebuttal time.
Thank you, Your Honor. Unless any specific questions, I'll use my rebuttal time to address this claim that Mr. Snodgrass actually sabotaged the system, and that's why he shouldn't be paid for his overtime. And I think the case that mainly the appellee is referring to is White versus Baptist Memorial. And we would just argue it's totally inapplicable. It's different facts. And we would argue this case falls right under Mount Clemens Pottery case. In White, the employer had a system for recording interrupted lunch breaks, because if the break is interrupted, then you get paid for that. If it's uninterrupted, they don't have to pay. So in this particular case, the employee just didn't use that system, and the employer didn't know, and there was no record to prove it. And so even under White, there is an exception, and that exception is if the employer knew about the overtime. And in this case, they certainly did know about it. They admit that there were GPS records that they monitored on at least at least every 2 weeks. So they're on notice, and they know that there's overtime here. So we would just argue this White case just simply doesn't apply. And of course, I've already covered that even if Mr. Snodgrass, well, I don't think I did cover this, but I think this was raised, that if Mr. Snodgrass did refuse to clock in, he should have just been disciplined. And, and they could have fired him, they could have disciplined him, they didn't. They were more than happy to just pay him 40 hours, even though he was working more. So Mount Clemens is just squarely more applicable, we would argue. And there was a system here that was used. It showed unworked overtime, and we would ask the court respectfully to enter judgment, or to reverse and remand for the lower court to enter judgment on each week that Mr. Snodgrass was not paid overtime. And we're also asking that the court not deduct the 5 hours for lunch periods, because they were interrupted lunch periods. Both sides agree with that. And my time is up, unless there's any questions.
Well, how would the employer know about interrupted lunch times in this case?
Well, in this case, there should have been a system for recording it, likely. There wasn't a system. The employer actually conceded. They agreed that he didn't get one, that he was running from one work site to the next, and he just had time to eat a sandwich.
So when we read the record, we'll find proof from the employer that they knew that he was missing his lunch breaks.
Yes, Your Honor.
Will there be proof in the record that the employer thought that he was working overtime?
I don't know if it says that explicitly. I think there's proof in the record that that they did review the GPS records and that they were aware of the time he was working. So I think they were on notice.
I'll just go back to my very first questions. How does a GPS record with regard to tracking a vehicle tell you whether or not an employee is engaging in compensable work activity? It only tells you that they're sitting, idling in a vehicle. It doesn't tell you whether or not they're working.
Well, Mr. Snodgrass, I think, was believable on that point, and the trial court found that he did meet his initial burden by his testimony. And
Did the trial court make any credibility determinations?
well, maybe by inference. I don't recall in the judgment it saying specifically that this witness was found more credible than this, but I think maybe by inference they did.
Okay.
I don't know how specific it was.
I want to ask you about the lunch. Are you saying that he's entitled, that these lunch hours should also be included as overtime? When I realize, go back to this agreement, 40 hours a week plus he was to take an hour lunch. That was initially the agreement. So I mean, is he entitled to be paid for that lunch hour as overtime too?
Yes, Your Honor, we would argue that's the case. I mean, any time under the FLSA that is interrupted, that is scheduled for lunch break, is considered work time, even if he's eating lunch. So I think he does have to be paid for it. So in other words, if there was 40 hours of work and then there was an hour lunch break, and that he would have to be paid for that hour lunch break as well. And if that pushed him into overtime, then it pushed him into overtime. Or let's say that he worked 45 hours plus a lunch break, he should be compensated for 6 hours of overtime, because that lunch break would be overtime.
What was the proof on the lunch break?
I believe that Mr. Snodgrass just said basically that he didn't have time for a lunch break, he would eat a sandwich, and the other side basically conceded that he wouldn't have had time to eat it. And I don't recall exactly what it says, but
I'm sorry, what did the other side concede?
If that was the case, that he would have just been running from one work site to the next, and he'd have a chance to quickly eat a lunch, and that there was not going to be a time for like an uninterrupted 1 hour break during his work.
They conceded
period. That's my recollection, Your Honor.
All right. Question? Thank you.
Okay, thank you, Your Honors.
Thank you, gentlemen. Very interesting argument. We'll take this under advisement and render opinion as soon as possible. Feel free to go.